Article 21A, Right to Education. This was introduced by the Constitution 86th Amendment Act 2002. According to this, the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Protection against arrest and detention. Although Article 21 does not impose a limitation on the legislature insofar as the deprivation of life or personal liberty is concerned, yet a legislative act providing for such deprivation is subject to the procedural safeguards provided in Article 22, and if it does not provide for any of these safeguards, it shall be declared unconstitutional. However, Article 22 does not apply uniformly to all persons and makes a distinction between alien enemies, person arrested or detained under preventive detention law, and other persons. So far as alien enemies are concerned, the article provides no protection to them. So far as persons in category C are concerned, it provides the following rights. These rights are not given to the persons detained under preventive detention law. A person who is arrested cannot be detained in custody unless he has been informed as soon as he may of the grounds of such arrest. Such person shall have the right to consult and to be defended by a legal practitioner of his choice. A person who is arrested and detained must be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time of journey, and such a person shall not be detained in custody beyond 24 hours without the authority of magistrate. Preventive detention. Preventive detention means detention of a person without trial. The object of preventive detention is not to punish a person for having done something but to prevent him from doing it. No offense is proved nor any charge formulated, and yet a person is detained because he is likely to commit an act prohibited by law. Parliament has the power to make a law for preventive detention for reasons connected with defense, foreign affairs, or the security of India. Parliament and state legislatures are both entitled to pass a law of preventive detention for reasons connected with the security of the state, the maintenance of public order, or the maintenance of supplies and services essential to the community. Safeguard against preventive detention. Article 22, amended by the 44th Constitutional Amendment Act 1978, contains following safeguard against preventive detention. Such a person cannot be detained for a longer period than 3 months unless an advisory board constituted of persons who are or have been or are qualified to be High Court judges has reported before the expiration of the said period of 3 months that there is, in its opinion, sufficient cause for such detention. Parliament may by law prescribe the maximum period for which any person may in class or classes of class be detained under any law providing for preventive detention and procedure to be followed by an advisory board. The authority ordering the detention of a person under the preventive detention law shall communicate to him as soon as may be the grounds on which the order for his detention has been made, and afford him the earliest opportunity of making the representation against the order. It may, however, be noted that while the grounds for making the order are to be supplied, the authority making such order is not bound to disclose those facts which it considers to be against the public interest.